Hi, I'm Aslam and I am a registered attorney, and in today's video we are talking about Rule 43 when it comes to divorce matters. In particular, we're going to be looking at the legal documents that are required. A Rule 43 is an interim maintenance application that parties go through when they need maintenance before the divorce is finalized. In other words, a person who wants money to look after themselves or look after their children, one spouse against another, will bring an interim application, which means that it's not final, but it's just money to come in while the divorce is being finalized. So the person who is applying to court, we call them an applicant. The person who has to respond, we call them a respondent. Let's go through the applicant's statement in terms of the Rule 43. They fill a document where they confirm their details. Number one, they confirm the respondent's details. They talk about what kind of marriage system they were married in. For example, a marriage in community of property or a marriage out of community of property. They also talk about children from the marriage. They talk about why the marriage relationship has broken down, what are the reasons, and most importantly, now they set out the grounds for how much of money they want. When we talk about grounds, there are a couple of things that you need to look at. Number one, is the applicant employed in a full-time or part-time position? How much of salary do they get? Or how long have they had that position for? What are their monthly costs? You're going to then total that amount. After that person deducts their expenses, what is the amount of money they have left in their account? Is there a shortfall or a surplus? Then you also got to consider during the marriage, who was responsible for paying what? Was the husband going to pay the rent and the lights and water? Was the wife going to be paying those expenses, etc., etc.? Also, you look at different assets of the relationship and what happens to medical expenses. At the end of that statement, the applicant summarizes what she is looking for in terms of a financial amount and how much she also needs a contribution to legal expenses. Yes, you heard that right. You can get the respondent to help contribute to your legal expenses during the divorce. Now let's look at it from the respondent side. We've covered it from the applicant side. Let's look at it from the respondent side. Now the respondent's defense is quite simple. The respondent does a replying statement or a replying affidavit where either they admit or deny the claims that are made by the applicant. Let's assume that they are going to deny them. Now, if you deny them, you must have valid grounds for denying them, which means that if that person says they need 2,000 Rand or 20,000 Rand, you say you're only prepared to give 1,000 Rand, then you must be able to substantiate why you are only prepared to give 1,000 Rand. Is it because your salary is being cut? Is it because you are going through retrenchment? Is it because your expenses have increased? You need bills to prove your own case. If that person requires contribution to legal costs, are you going to get an attorney of your own? These are the questions that need to be considered. I highly advise that you seek out the services of an attorney in drafting these legal documents. If you need help in your situation, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best and I'll speak to you soon.